Can you sue a personal representative for stealing in the state of Florida? And the answer is absolutely you can sue, but the reality is you don't even have to do that because suing's harder than just pleading this up and getting it in front of the judge that has authority over the probate case. There's an interesting concept that people really need to understand, and this is the concept of a probate estate, right? So bankruptcy lawyers are familiar with this, and people who have been through bankruptcy understand this, but an estate is created when a judge takes jurisdiction over whatever it is. And when someone dies, boom, the instant of death, that estate, everything in it, from the pieces of paper to the junk in the house to the real property to the bank accounts, everything can become under the jurisdiction of a judge. And this critical concept is something that really needs to be understood because oftentimes it's forgotten about. It's kind of overlooked, even among people who have been doing this forever. But the deal is this. When someone dies, the whole point of appointing a personal representative is a human being who's alive now because we got someone that's dead. And when that person goes and unalives themselves, they can't do anything. Not usually. Sometimes they can. They can click on your computer and transfer funds and things like that. But the reality is the whole point of a probate estate is once this person goes and makes himself unalive, someone that's on the other side of the curtain has to step in and move the money around and get the house titled properly and make sure that Maserati that's being driven around is properly insured and that the title gets into the correct name. And that's literally what probate is, right? So the judge appoints someone, the personal representative, and that someone's job is to make sure all that money goes where it's supposed to go, make sure that car goes where it's supposed to go, make sure all the knickknacks and paddywhacks and stuff in the house, make sure they go where they're supposed to go. But too often sometimes someone decides with their hot little sticky fingers, they're going to jump in there and they're going to grab something out of that house when someone died. I just had that happen literally today. I had police meet me out of the house because after this person had died, period of time in which the house is vacant, and people had gone in there and helped themselves to whatever is there. And that's a real big problem because now we got to try and figure out who took all this stuff. So big part of what I do at the front end when someone is unalive is I talk with people about securing that estate, locking it down. And that means keeping the security systems alive, the Ring cameras, all that stuff. I deal with rural property. I tell people go down to Home Depot or go down to Best Buy, get them trail cameras because we've got rural areas, right, where you need to know if your kid died down here and he's got a house, you got to make sure that people aren't breaking in there and taking stuff. And you live up in Michigan, you can't be their eyes on the whole time. So you get trail cams set up that can send pictures if someone's going in there and breaking in. You keep the security cameras on so that you can literally see what's going on. But the idea that the personal representative or whomever's in control has a responsibility to secure and inventory the estate is a critical part of the responsibility. And, if we're dealing with, figurines and stuff like this, we got to make sure all that stuff is inventoried perfectly. If we're dealing with valuables like jewelry and things like that, we got to make sure all that stuff is inventoried and taken care of very properly with fiduciaries. I will not walk into a house unless it's properly secured or there with the personal representative. I make sure the personal representative is very clear about that as well, about protecting themselves from accusations from the other people over here that they take and stuff. There are very easy ways to do this. We video stuff. You go in there, you inventory it, and that's about protecting the PR over here and protecting them from improper allegations over here on the other side of it. But again, in those circumstances where the PR thinks they get sticky fingers, and I've had cases where they go in the garage and the PR is taking tools and stuff like this. Sometimes this stuff is very valuable, and the PR is just taking it, helping himself to it. And lo and behold, we find out that the miter saw and the tools and all this other stuff happens to be at the PR's house. Whether it's a little bit of money or a lot bit of money, doesn't matter. PR sits in a role of a lot of power. It's a fiduciary role, and they better understand really clearly at the front end, you can't just help yourself with your sticky little fingers to any of this stuff. But the answer to the question is, Can that PR that's taken anything be prosecuted? The answer is absolutely. They can be held personally liable. Another part of this is there's a bond that's out there. What does a bond mean? Well, a bond is an insurance company that comes in and protects the heirs if the personal representative's gotten sticky fingers. One of the problems is these bonds are oftentimes really low, so it's hard to come after. Typical one is 18,000. In the cases where that was people being honest and things are simple, 18 maybe is fine. I think it's far too low these days. If I were a judge, I'd be having $100,000 bonds in virtually every single case. Another huge problem I've seen, there's this tendency had been to have what we call no bond cases, which is the PR is appointed and there's no bond at all. So that means if the PR steals, it's up to these people to try and get it, and oftentimes there aren't assets. So I think the circumstances under which there should be no bond should be very, very limited anymore. I think judges are going to start to get burned on this over and over again, and we're going to start to see less and less cases in which there are no bond cases. The reality is the bond fee is really low, a couple $100, and it just makes sense to get that bond to protect yourself if you're the PR. Judge, you got to order that bond no matter what to protect the assets. But the more interesting question about all this is, what's the timeline to bring this stuff? And the answer to that question is, it better be right away. If you find out the PR is stealing, if you think the PR is stealing, that's your cue. Hire an attorney, hire a private investigator, go video it, talk to the neighbors. If you're a beneficiary, you can do this stuff. There's no harm in it, and you should start collecting that information right away. Well, I think the true reality is, breach of fiduciary duty, that stuff's 2 years from when you discover it. The more interesting question in my mind is bringing it before the estate is closed. Because if you read the paperwork on when a PR is discharged, the judge signs a document saying the PR has faithfully discharged their duties, and it's a hell of a lot easier to bring all these allegations of stealing up against the PR before that document is signed and entered. Look at FloridaRules.net. We got all the details in here about how you plead this stuff.